Good afternoon, everyone. You can respond. Good afternoon, everyone. That was much better. Welcome to the 13th annual Live from L, featuring speakers from the U.S. Department of State Office of Legal Advisor. Today's program is presented by the American Bar Association International Law Section and co-sponsored by the American Society of International Law, George Washington University Law School, and Howard University School of Law, this year's host for the event. I'm Danielle Hawley, Dean of Howard University School of Law, and it is my pleasure to welcome our audiences here at Howard University School of Law and online. This year's theme for Live from L is on Russia's war against Ukraine. We are fortunate to welcome State Department Acting Legal Advisor Richard Visick and attorney advisors from the Office of the Legal Advisor, also known informally as L, to present on such a timely topic. Howard University and Howard University School of Law have a long and rich history with the U.S. Department of State. One of my predecessors, Howard University School of Law Dean C. Clyde Ferguson, served as U.S. Ambassador to Uganda and Ambassador at Large and Coordinator for Civilian Relief during the Nigerian Civil War. Another former Howard Law Dean, Patricia Roberts Harris, was appointed by President Lyndon Johnson as Ambassador to Luxembourg. She became the first African-American woman ambassador to a foreign nation. Goler Teal Butcher, a graduate of Howard Law, began her career in international law at the State Department Legal Advisor's Office in 1963, and she went on to a distinguished career in international law, including service as an assistant administrator at USAID and a professor at Howard University. Currently, we are privileged to have an alum of L, Professor Darren Johnson, serving on our faculty. One of our students, Favor Okuhuvbi, I hope I pronounced that close to correctly, is also currently serving as an extern within L. We look forward to continuing and deepening our rich engagement with the State Department and the Legal Advisor's Office. It is my pleasure to now turn to Professor Johnson to moderate today's panel. Welcome to all of our panelists.
Thank you so much, Dean Hawley. And before we begin, we'd just like to take a moment to thank the primary sponsor for today's event, the American Bar Association, for their wonderful work, and acknowledge Ron Batower, Robbie Nightingale, and others who've helped to organize the event. We will have a more fulsome thanks towards our organizers at the end of the event. Just to begin, I'd like to note that as a former attorney advisor in L, I'm particularly excited to moderate today's panel, which falls upon the one-year anniversary of the Russian invasion into Ukraine, at least this phase of it. Last week, Vice President Harris announced the administration and State Department's determination that Russia has committed crimes against humanity in Ukraine. And President Biden, in his remarks in Poland, noted that we continue to maintain the largest sanction regime ever imposed on any country in history. And President Biden also promised that we will hold accountable those responsible for this war, and that we will also seek justice for the war crimes and crimes against humanity which continue to be committed. The State Department Legal Advisor's Office plays a central role in the formation and implementation of all of these legal and policy pronouncements. We're very fortunate today to hear from members of L about their important work supporting these efforts. A note on the format of the program. So the first portion of the panel will include remarks from all of our panelists, and we will reserve time at the end for questions. So I encourage all of our viewers who are online to make sure that you submit questions throughout the program online using the Q&A button. Time allowing, we will also get to as many questions as possible submitted online and that are also offered by participants in the room. It is my distinct honor to now introduce Richard Visick. Rich Visick is the acting legal advisor of the U.S. Department of State. Richard Visick joined the State Department Office of the Legal Advisor in 1999. He became deputy legal advisor in 2011 and then principal deputy legal advisor in 2016. Since that time, he has served for a number of years as the acting legal advisor. During his tenure in L, Richard Visick has served in offices from law enforcement and intelligence matters to legislation and appropriations to European and Eurasian affairs. And over the course of his career, Mr. Visick has received numerous awards, including 2 distinguished and 1 meritorious Presidential Rank Award, the Secretary of State's Distinguished Service Award, and the Attorney General's Distinguished Service Award. Without later ado, Mr. Richard Visick.
Well, thank you, Darren, and it's a pleasure to see you again. And on behalf of the entire Office of the Legal Advisor at the U.S. Department of State, I want to thank you. I want to thank Dean Hawley, Howard University Law School for hosting this year's Live from L. We also want to recognize the efforts of Howard University Law School's International Law Society. I think they put a lot of the sweat equity into this event, so thank you to them. Also want to thank our other co-sponsors, the American Bar Association, International Law Section, the American Society of International Law, and George Washington University Law School, all of whom have been outstanding supporters of this program over the years. We are very grateful to connect with those of you who are in the room here today at Howard Law School, and those of you who are participating courtesy of the ABA providing a virtual platform, those of you around the world, in fact. Since 2011, it has been our pleasure to talk about some of the issues that the Office of the Legal Advisor works on. This is, I think, as Dean Hawley mentioned, our 13th Live from L, and L again being the acronym for the Office of the Legal Advisor in the acronym-rich State Department. And we have talked about such issues as cyberspace, South China Sea, climate change, and so many others. And today, of course, we're going to be focused on Russia's aggression against Ukraine and our legal response to it. The Office of the Legal Advisor, just for those of you who don't know, we are in effect the General Counsel's Office to the U.S. Department of State. We have about 300 attorneys with the great privilege of providing guidance to policy makers on addressing all the foreign policy challenges that the United States faces, and in fact that the world faces. We also advise on, and this is equally important, the many aspects of supporting the operational platform for the department, without which there could be no foreign policy initiatives. So we are A to Z, soup to nuts Office of Legal Counsel. We're also supported by an outstanding team of paralegals, analysts, and other support staff. And we also have the benefit from having outstanding externs and interns through the course of the year. And Dean Hawley has already recognized Favor Okuevi's participation in our internship program. And I see Favor right there. I don't know if you want to just wave your hand, or was she that? Oh, I'm sorry. I thought somebody waving. Okay. And she's a second year, and she's working in our private international law office and working on basically international law and instruments affecting commercial transactions that cross borders. And we are always, and I say this to those of you in this room, and I say those to those of you online, we are always looking for great interns, externs, and applicants to the Office of the Legal Advisor. We have a coffee mug, and it is on that coffee mug is best job ever. And I guarantee you that if you come to work for the Office of the Legal Advisor, you'll realize that's the case. Not that there aren't other great places to work. For this 13th edition of Live from L, we are going to focus on Russia's aggression against Ukraine and the international response, and specifically the legal response to it. Just over a year ago, the Russian Federation mounted a brutal, full-scale, further invasion of its neighbor, Ukraine. And the reason I say further invasion is obviously in 2014, Russia invaded Crimea. As Russian tanks rolled across the Ukrainian border, and the world watched anxiously to see whether Kyiv would fall, President Biden asked President Zelensky what he could do to help. President Zelensky responded, quote, gather the leaders of the world and ask them to support Ukraine. A year later, we witnessed President Biden visiting President Zelensky at the Mariinsky Palace in Kyiv. And as President Biden recounted that earlier discussion with President Zelensky, he affirmed, he said, quote, Kyiv stands and Ukraine stands, democracy stands. While ultimately that is a tribute to the strength and courage of the Ukrainian people, it is also due to the broad international support that Ukraine has received from the United States and other states around the world. Throughout the conflict, US policymakers, guided by the attorneys at this table and so many others at the Department of State, as well as in the interagency, have looked to international law and international institutions as important tools to organize and advance international action to support Ukraine and to hold Russia accountable. In the run-up to and in the immediate aftermath of the 2022 invasion, L attorneys were very quick to respond, advising clients at the State Department and in the interagency on such issues as maintaining our diplomatic presence in Ukraine amidst an armed conflict, imposing effective sanctions against Russia, assisting civilians fleeing the conflict, and critically, delivering vital defense articles and services to Ukraine. As the conflict has progressed, L has provided guidance to clients on the development of 6 United Nations General Assembly resolutions addressing Russia's aggression. We've drafted and filed the United States Declaration of Intervention in proceedings before the International Court of Justice that were initiated by Ukraine against Russia under the Genocide Convention. And we've provided legal analyses to policy officials on Russia's use of force and on the law of occupation. L has also been hard at work advising clients on the legal implications of the conduct of Russia's forces and helped inform the department's determination that Russia and its forces have committed war crimes. In fact, we made that initial war crimes determination fairly early on in the conflict. In addition, as has already been mentioned, Secretary Blinken recently determined that members of Russia's forces and other Russian officials have committed in Ukraine crimes against humanity, a determination reserved by the department for the most egregious crimes. Vice President Harris announced this determination at the Munich Security Conference, where she affirmed these crimes as barbaric, reprehensible, and inhumane. In addition to advising on these determinations, L has been hard at work exploring an array of methods for pursuing justice for the people of Ukraine, from the creation of a civil registry of damages to appropriate justice mechanisms to prosecute the crime of aggression. From the outset and continuing to this day, L attorneys have coordinated closely with foreign legal counterparts to ensure that we are also together on the law. We consult frequently with our Ukrainian colleagues in Kyiv, as well as their people here in Washington at their embassy. In addition, we have regular legal dialogues with G7 partners, which includes legal advisor counterparts from Japan, the United Kingdom, France, Italy, Germany, and Canada. And we also regularly meet with lawyers from the European Union and have met with legal advisors and foreign ministry counterparts at the Council of Europe, which is located in Strasbourg, at the United Nations in New York, and at NATO in Brussels. Such legal diplomacy has proved incredibly useful as we've navigated new and often complicated legal issues. Today, I am pleased to be joined by an incredible group of attorneys from L who have been hard at work on supporting the United States' response to the situation in Ukraine. With me today are my colleagues, Meredith Johnson to my right, who is an attorney in L's Office of European and Eurasian Affairs. Next to her is David Saley, who is an attorney in L's Office of Economic and Business Affairs, who advises on an array of sanctions issues. To my left is Noah Brown, who is an attorney in our Office of UN Affairs, which advises on all things involving international institutions and their work with respect to Ukraine issues. And then at the end of the table, and certainly not least, is Jessica Thibodeau, who is an attorney advisor in L's Office of Political Military Affairs, where she advises on legal issues related to the use of force and the law of war. So with that, hopefully not too long introduction, I'm going to turn it over to my colleagues to carry on. And with that, I'm going to turn it immediately over to Meredith Johnson.
Thank you. It's a real pleasure to be here today. As Rich mentioned, I'm in our Office of European and Eurasian Affairs. And so I'm going to start by providing factual background on the situation in Ukraine that will sort of serve as the basis for some of the legal topics we'll talk about. And then I'll give a brief overview of how my office fit into all of these efforts. So as Rich mentioned, this war hasn't been going on for 1 year, it's been going on for 9. Russia first invaded in 2014. And so I actually want to take us back to 2013, shortly before the initial invasion, because I think this history is helpful to bear in mind, because what happened in 2014 and the international community's response to it informed what Russia did in 2022. So in late 2013, Ukraine's pro-Russian president, Viktor Yanukovych, refused to sign a trade and political association agreement with the EU. The agreement was popular in Ukraine. It had already been approved by the parliament. And more importantly, it symbolized Ukraine's greater integration with Europe over Russia. Yanukovych's actions prompted protests across Ukraine, particularly in Kyiv, calling for him to resign. In response, the government cracked down on the protests, often violently. Ultimately, the protests were successful, and President Yanukovych and his ministers fled, and a new interim government led by the opposition took office in late February 2014. The Kremlin watched these developments with increasing alarm and began mobilizing Russia's forces in response to the protests. Within days of the change of government in February 2014, Russian forces had infiltrated Ukrainian military and government institutions on the Crimean Peninsula and seized them. Russia quickly installed pro-Russian officials in local government, which declared a short-lived so-called independent Crimea, and orchestrated a so-called referendum on whether Crimea should become part of Russia. By mid-March, Russia had purported to annex Crimea and claimed it as Russian territory. In response, on March 27, 2014, the UN General Assembly passed a resolution denouncing the referendum and refusing to recognize this purported annexation. The vote was 100 nations in favor of the resolution, 11 against, and 58 abstentions. And I mentioned this vote count because it will be an important comparison point for some of the UN General Assembly resolutions that were adopted in 2022 that my colleague Noah will talk about. At the same time as Russia was moving into Crimea, Russian-led groups began fighting in eastern Ukraine. By April 2014, these groups had gained control over parts of Donetsk and Luhansk oblasts. Oblast is the word for region or state in Ukraine. Again, these groups orchestrated sham referenda on whether the regions should be independent from Ukraine, and they claimed to establish the so-called Luhansk People's Republic and Donetsk People's Republic. Although there was no UN General Assembly action, other states did not recognize these purported claims to independence. And in response to the entire situation, the United States on its own issued a number of sanctions. The situation with Russia and Russia-led groups controlling Crimea and parts of eastern Ukraine remained relatively deadlocked from 2015 until 2021. In February and March 2021, there were large Russian troop movements in Crimea near the Russian-Ukraine border, as well as movements of ships from the Caspian Flotilla to the Black Sea Fleet. Ukraine requested OSCE inspections under what's called the Vienna document. Russia declined to engage. And in July 2021, a manifesto under Putin's name titled "On the Historical Unity of Russians and Ukrainians," denying that Ukrainians existed as a separate people, was released. Starting in October, November 2021, with tens of thousands of troops maneuvering in Russia near its borders with Ukraine, in Crimea, and notably in Belarus, the United States began warning of the risk that Russia would launch a full-scale invasion of Ukraine. and warned Russia of a strong response if it did. Russia denied that it intended to invade, but at the same time began asserting various pretexts for an invasion. For example, it claimed that Ukraine was committing a genocide against Russian-speaking Ukrainians. It compared Ukrainian officials to Nazis. It made various claims that Ukraine and NATO presented a direct threat to Russia. And immediately before the full-scale invasion on February 21st, 2022, Russia purported to recognize these so-called independent republics in eastern Ukraine. And then it claimed that these new independent states, as it claimed, had requested Russian assistance to defend themselves against Ukraine. So on February 24th, as you all know, Russia launched its full-scale invasion, and almost immediately we all started seeing reports of the brutal consequences of the war for Ukrainian civilians. And this derailed nation peace discussions between Russia and Ukraine. Media outlets and academic sources began reporting that members of Russian forces were committing war crimes and other atrocities in Ukraine. Russia failed to take Kyiv in 3 days. It was driven back from the capital by the end of March, and it refocused on eastern Ukraine. And by late August, the Ukrainians had mounted a wildly successful counteroffensive in Kharkiv and regained control of much of northern Ukraine. However, Russia's forces still occupy not just Crimea and parts of eastern Ukraine, but also parts of Kherson and Zaporizhzhia Oblast as well. In September, Russia organized so-called referenda yet again in Luhansk, Donetsk, Kherson, and Zaporizhzhia on whether these regions should become part of Russia, much like it had in Crimea in 2014. And again, just like in Crimea, Russia used the results of these sham referenda to try to justify its claims to have annexed these areas as Russian territory. At the same time, it was trying to annex territory. It was losing to Ukrainian forces. They made progress and retook control of some of these regions, including the city of Kherson. So that's the factual background. I want to talk a little bit about how my office fit into the legal questions that were coming, a host of legal questions that were coming to the State Department. First, as the regional office, we often serve a coordinating function, an issue spotting function for these types of questions, which I'll identify kind of three buckets. The first were these questions about violations of international law, some of which Rich mentioned, and Jess will talk more about them. And the reason we were being asked to look at these in detail is there was a deliberate policy interest in explaining that this wasn't just a conflict between the East and the West, between the US and Russia. This was a conflict that challenged sort of the fundamental rules of international law that had been put in place in order to maintain international peace and security, or when conflict does happen, to protect and minimize harm to civilians. So that's the international law bucket. We were also asked what legal options are available to the United States to respond to this situation. And so my colleague David will talk about sanctions, and my colleague Noah will talk about the efforts of the UN to develop some of those legal options about what we could do. And then finally, a third bucket was really kind of practical issues. How do we keep our diplomats safe? How do we provide humanitarian, economic security assistance to Ukraine in line with US law? And we were coordinating and working with our colleagues on all of that. And then there's another area where involving the regional organizations. So my office has a lot of expertise with the European regional organizations, the EU, Council of Europe, NATO, OSCE. And so we were very involved in some of the issues there. So for example, last year, NATO decided to ask Finland and Sweden to begin the process to become parties to the North Atlantic Treaty. And so we worked with experts in our treaty office and others to ultimately on a process that led to the Senate giving advice and consent to Finland and Sweden becoming NATO allies. There are, and I'll talk about this at the end, ongoing efforts in the European regional organizations to pursue accountability for what's happening in Ukraine. And I'll talk a little bit about that. I do want to say that this was a really collaborative process. And given that we have so many law students here, I just want to stress, at least when I was in law school, I felt Like the job options that were presented to me were all adversarial. You know, you could be a litigator, you could be corporate counsel, and those were your choices. And for me, I found it really gratifying to be in a much more collaborative role, to be working as part of a team, not just with lawyers, but also with our policy clients, to try and address some really challenging and important problems. So with that, I will turn it over to my colleague, Noah. Thanks.
Great. Thank you, Meredith. My name is Noah Brown. I'm an attorney in the Office for UN Affairs. And what I'd like to do in a couple of minutes today is just walk you through the action at the multilateral level in the last year or so. So starting with the Security Council. The Security Council, for those who don't swim in these waters frequently, the Security Council is one of the principal organs of the UN. It's charged with the primary responsibility for the maintenance of international peace and security, and it has the ability to adopt resolutions that are binding as a matter of international law. There are 15 members of the Security Council, 5 permanent members, the US, France, UK, China, and Russia, and there are 10 elected members who rotate every couple of years. Importantly, the 5 permanent members have the right to veto a resolution to prevent action from the Security Council. So with that setting, as Meredith mentioned, the US had been warning of Russia's massing of troops along the border and of its plans to further invade Ukraine. The US called an emergency meeting of the UN Security Council on February 23rd last year. During that meeting, President Putin from Moscow announced the start of what he called the special military operation in Ukraine. 2 days after that, the US and Albania, an elected member of the UN Security Council, co-sponsored a resolution condemning Russia's aggression in Ukraine. That resolution got the support of 12 UN Security Council members, but it was vetoed by Russia. So it did not go anywhere. China and India abstained on that resolution. So at that point, now you can't move forward in the Security Council because of the Russian veto. So the UN Security Council then voted to convene what is called an emergency special session of the General Assembly. And so for when in instances in which the Security Council is unable to act on a question that pertains to international peace and security, the General Assembly of the United Nations can convene this emergency special session to take up the issue and make recommendations. So now the action moves from the Security Council over to the General Assembly. The General Assembly is yet another organ, a principal organ of the United Nations. It consists of every UN member state. There are no vetoes, and it does not have the ability to adopt resolutions that are binding as a matter of international law. So I want to walk you through what has happened in the General Assembly in the last year. And to my mind, the action has been prolific. The General Assembly has adopted 6 resolutions pertaining to the conflict in Ukraine. The first one was just about a week after Putin made his announcement, and it condemned, the General Assembly voted for a resolution to condemn Russia's aggression and to deplore it as a violation of Article 2.4 of the UN Charter. So basically telling Russia and telling the world that Russia's actions had violated the UN Charter. That passed the General Assembly with a score of 141 votes in favor and just 5 against, with a couple of dozen abstentions. Fast forward a couple of weeks until late March, the General Assembly passes yet another resolution condemning the humanitarian consequences of the war in Ukraine and its effects on global food insecurity, which unfortunately we've seen play out. That again passed by overwhelming margins in the General Assembly. Fast forward to the next month, resolution number 3 in April, the UN General Assembly adopted a resolution that suspended Russia's membership from the Human Rights Council. The Human Rights Council is a human rights body in Geneva, of which Russia was a member. Because of a determination that Russia was responsible for gross and systematic violations of human rights in Ukraine, the General Assembly took the decision to suspend its membership, only the second time that has ever happened. Moving forward and dovetailing on what Meredith was talking about with respect to the sham referenda that were conducted in Ukraine, in October, the General Assembly condemned Russia's illegal so-called referenda in regions within Ukraine and the attempted illegal annexation of the Donetsk, Kherson, Luhansk, and Zaporizhia regions, and declared that those actions, quote, have no validity under international law. Resolution number 5, in November of last year, the General Assembly recognized the need to establish an international mechanism for reparation, damage, loss, or injury to persons and to the state of Ukraine, essentially recognizing that in a war, there are civil losses and there needs to be a mechanism to account for them, to gather evidence with respect to them and to catalog them. So that was passed. The General Assembly didn't create a mechanism. It recommended the creation of a mechanism. And just recently, we've heard in the last couple of weeks that the Dutch and the Ukrainians have agreed to create an international organization in The Hague to try to get this off the ground. And finally, resolution number 6, just last week, the General Assembly underscored the need to reach as soon as possible a just, lasting, and comprehensive peace in line with the Charter, the principles of the UN Charter, and again reiterated the unlawfulness of the Russian invasion and emphasized the need to secure accountability. What's interesting is the last resolution that I just referenced from last week had 141 votes in favor. That is the same number of votes that the first resolution got. So there's been a remarkable level of consistency and support for these resolutions. In addition to the action in the General Assembly, there's been a lot of action in the broader UN system as well. So UN agencies and other bodies have adopted resolutions condemning Russia's aggression, agencies as diverse from the International Atomic Energy Agency to the International Maritime Organization. And Russia has also repeatedly lost elections, been removed from committees, or been suspended altogether from international organizations. Most notably, the American candidate for Secretary General of the International Telecommunication Union in Geneva won in a landslide against the Russian candidate. So taking kind of zooming back, I think what we've seen is between these resolutions from the General Assembly, as well as the actions across the UN system, we've seen historic levels of global support condemning Russian aggression in Ukraine that have increasingly led to Russia's isolation in international fora. And so you might ask, well, what is the role of the lawyer in all of this, right? And at least the way I view it is kind of like a never-ending issue spotting exam, right? We read everything, every resolution, every speech, every talking point, every briefing paper carefully to ensure that we are saying what we believe an accurate rendering or an accurate understanding of the law to be. What types of legal issues come up? International humanitarian law, international human rights law, the UN Charter and treaties, the use of force, international refugee law, sanctions, international maritime law, the law of international organization, rules of procedures, the list goes on and on and on. So I hope that gives you a little bit of a sense of what was happening in the multilateral space in the last year. And I'd now turn it over to Jess to talk about the law of war.
Thanks, Noah. Hi, everyone. I'm Jess Thibodeau. I'm an attorney in LPM, which is our Office of Political Military Affairs, and I work on law of war and use of force issues. So as Noah just said, Noah and Meredith have talked a little bit about the history and our public-facing engagement, but I'm going to focus on 3 internal legal issues that we've considered that have really allowed us to join consensus on multilateral statements on the issues that Noah just talked about. So first question, the really fundamental question, is Russia's war unlawful under international law? Second, I'm going to talk about our legal analysis of war crimes and other atrocities being committed by members of Russia's forces. And finally, I'm going to talk about the law of occupation and how that particular body of law applies in this context. And just to reiterate what other colleagues and Rich noted at the top, the reason that I and others spent so much time over the last year looking at these questions goes back to our role as L lawyers. We are in-house counsel for our policy clients and ultimately the Secretary of State. And our clients love to make public statements characterizing conduct, in this case, Russia's conduct, in legal terms. So we do the analysis that allows them to forcefully use legal language in their diplomacy and messaging. So to the first question, and I should say, we looked at this question well before February 24th because it had become obvious to us, and President Biden and others had made clear to the international community what Russia was planning to do. So we considered whether a Russian full-scale invasion would be lawful under international law, because international law does permit the use of force in some circumstances. The body of law is called the Jus ad bellum. And Article 2.4 of the Charter that Noah mentioned is really the North Star of that analysis. And Article 2.4 prohibits the threat or use of force against another UN member state. But there are exceptions, as I just said, when states can lawfully use force. The main exception that could potentially be relevant here is the inherent right of self-defense. That's reflected in Article 51 of the UN Charter, but it's also part of customary international law. And it permits states to act in individual or collective self-defense in response to an armed attack. And international law provides that right applies not only if an armed attack has already occurred, but in response to an imminent armed attack before it occurs. So turning back to the question of Russia's conduct, the answer is clearly that Russia's conduct was unlawful here. The United States and the international community have widely condemned Russia's full-scale invasion as a violation of Article 2.4. So that was a relatively easy question for us to answer. But I did just want to flag, I found it interesting that despite Russia's utter disregard for international law, they have continued to talk about and try to justify their actions in legal terms. So one example is on the day of the full-scale invasion, Russia's permanent representative at the UN in New York submitted what's known as an Article 51 letter, which is a notification to the UN that states have to do if they are going to engage in self-defense under Article 51 of the UN Charter. And Russia's argument, thinking back to the history that Meredith mentioned, was that these so-called independent republics in Eastern Ukraine, which were of course part of Ukraine, but Russia had recognized them as independent, had requested that Russia come and defend them from genocide that Ukraine was committing against them. So of course, none of that happened. It's all completely false. But I do find it interesting that Russia put that out into the international community. Before moving on to the atrocities piece, I did actually want to talk specifically about the role of Belarus, because this was another question that we considered within L in the first week or two of the full-scale invasion. As Meredith mentioned, Russia invaded not only from its own territory, but also from Belarusian territory from the north. And for months prior to February 24th, was building up equipment and troops in Belarus. In the legal lens is that under international law, a state can be held responsible for aiding or assisting another state in the commission of an internationally wrongful act. And under the relevant tests, a number of criteria have to be met, including that Belarus as the assisting state is aware that its assistance will be used for an unlawful purpose and intends for its assistance to be used in that way. So from the very start, our policy clients had a strong interest in calling out Belarus. And so we looked into this issue. There were a lot of factors at play, but we assessed that Belarus was clearly aware of Russia's invasion and had known for some time, given the buildup. We also assessed that it was reasonable to infer that Belarus intended for its territory to be used in this way, in part because after the full-scale invasion actually happened, Belarus did not protest and has in fact allowed this to continue for well over a year now. But that's the kind of analysis we did in order to enable our clients to say things like Belarus is aiding and abetting Russia, or Belarus is complicit in Russia's aggression. things like that. And we've used that language for some time now. And I think our clients, of course, want to call out Belarus and make sure there's accountability, but I think there's some hope that there will be a deterrent effect to other states who might be considering supporting Russia by selling them weapons or things like that. So the second issue I want to talk about is war crimes. We've all just been inundated by the atrocities of what's going on in Russia. It's awful, and it gets worse and worse every day. And our policy clients had a very, very strong desire, as Rich said, almost immediately after the war started, to call out Russia in legal terms as having committed war crimes. So just as a very general matter, as I said before, the jus ad bellum are the rules governing the resort to force. There's another area of law, jus in bello, which is the rules once you're in hostilities, the rules that govern the conduct of the parties. So under international law, these two bodies of law are separate. And one reason for that is regardless of who started the war, who was at fault, the law requires that both parties abide by the rules governing the resort to force, and in particular, the rules governing the protection of civilians. You know, at a very high level matter, IHL requires parties to armed conflict to respect civilians and civilian objects. You cannot target civilians. You cannot engage in indiscriminate attacks that don't distinguish between civilian and military objectives, things like that. IHL is found in both customary international law and treaties. You're probably most familiar with the Geneva Conventions. So there are 4 original conventions from 1949, just after the World War II. And then there's one additional protocol from 1977 that deals particularly with international armed conflicts, which is a conflict between 2 states like that one. I deal with those treaties all the time. I look at them probably on a daily basis. And so they really provide the framework for the analysis that we've done in L on war crimes. As you can imagine, I'm sure it's highly fact specific when you're looking at particular attacks to assess whether an attack violated the law of war. It depends on the intent of the attacker, what was going on at that particular site, whether it was a military objective, things that we might not have full insight into as outsiders. But we do, there's been amazing open source reporting in this context. We also, of course, have intelligence reporting that we have access to. And we did, as Rich said, in March of 2022, we reached a determination, or I should say, we advised the Secretary, and the Secretary of State reached a determination that the US government assessed that members of Russia's forces had committed war crimes. Since then, a growing number of states have reached similar conclusions, and Ukraine itself is pursuing war crimes prosecutions in its own domestic criminal system. And the State Department and other parts of the US government are providing significant support to Ukraine to help it in its efforts. So the last topic I'm going to touch on is the law of occupation. This is not nearly, in my view, as well known an area of law as the others I just talked about, but it's become really important in this context. Since 2014, the US has assessed that Crimea is occupied by Russia, but more recently, given recent events, lawyers in L, along with our interagency colleagues from the Department of Defense and other agencies, have had to consider whether areas outside of Crimea are occupied by Russia. And the reason why that's important is because before you know whether a state or an individual actor has violated international law, you have to know which bodies of law apply. And there's a whole body of occupation law, largely set out in the 4th Geneva Convention, but a few other treaties. So that's one reason why we in L have been really focused on this issue and trying to educate our clients about why it's so important. Now, just very briefly, occupation is a question of fact, as we say. That means that if the facts on the ground meet the applicable legal standard, territory is occupied, regardless of whether the occupying power acknowledges itself as an occupying power. The standard for occupation is set out in an old treaty from 1907, but at least in my mind, I think about it as essentially having 2 components. The first is that a hostile army has taken physical control of territory, but that is not enough. The occupying power must also have displaced the territorial state's authority and be able to exercise its own authority. So in some ways, I almost think of it like a trustee role, where the occupying power steps into the shoes of the territorial state to sort of govern the territory and provide for the needs of civilians. Now, EL has assessed with interagency colleagues that Russia is an occupying power in several additional oblasts of Ukraine beyond Crimea, including Donetsk and Luhansk, and other areas of eastern and southeastern Ukraine. You've probably read about all the ways that Russian occupation authorities have asserted authority there. But for example, they have abducted and replaced local Ukrainian mayors with their own installed leaders. They have changed the education system, the currency, the language into the sort of Russian system. And we assess that based on all those facts, Russia was indeed an occupying power. You know, one of the reasons that's important is because it helps us in our public messaging combat Russia's false narrative that it has annexed these territories and made them part of Russia. That is absolutely not the case. And we can use the language of occupation to explain what Russia actually has done, because occupation law is very clear that it's temporary. It does not allow the occupying power to annex territory. It doesn't change the sovereignty of the underlying area. So we think that's been really helpful from a messaging perspective. I will also note, just in closing, that there are prohibitions on occupying powers related to the protection of civilians that our policy clients have been very focused on. One of those prohibitions is the prohibition on deporting protected persons, which generally are civilians, Ukrainian civilians, outside of occupied territory, including to another country like Russia. You might have heard about Russia's filtration operations. These are the system by which Russia and its proxies have picked up, detained, and screened hundreds of thousands, if not millions, of Ukrainian civilians. And they are essentially looking for clues as to how hospitable the civilians are going to be to Russian occupation. Now, our clients since the early stages of the war, really wanted to bring attention to what was going on with filtration operations. And one of the ways we did that is by doing a war crimes assessment and assessing that members of Russia's forces involved in this system had committed war crimes by forcibly deporting Ukrainian civilians to Russia. So that sort of ties in the occupation discussion with the atrocities discussion. So I will stop there for now. I'm happy to answer more in the Q&A, and I will pass it now to David Saley.
Thanks, Jess. Hi, everyone. My name is David Saley, and I work for the Office of the Legal Advisor for Economics and Business. That means my clients are in the Bureau of Economics and Business, and they oversee broadly most of the sanctions authorities in which the State Department is involved. For starters, I'll echo Rich's sentiment that he said was noted in the mug, that working at EL is the best job ever. I encourage those of you who are interested in international law to consider clerking, externing, interning, and eventually applying to law, to the legal advisor's office if you are interested in it. It's an amazing place to work. So sanctions. There are a number of authorities under which countries can impose sanctions. One of the overarching ones would be United Nations sanctions as imposed by a United Nations Security Council resolution. But as Noah noted, Russia with its veto power doesn't make that an available option now. Under domestic authorities, we also have a variety of authorities. However, the biggest and most important one for this case is the International Emergency Economic Powers Act, IEPA, that was passed by Congress in 1977. IEPA gives the president broad authority to prohibit U.S. persons from transactions with designated persons. And persons can be individuals or entities, such as a corporation. upon declaring a national emergency, the president can impose sanctions and freeze the assets of the designated persons. The actual operation is a prohibition of those U.S. persons from implementing transactions. And the president typically does this through an executive order. And in the Russia-Ukraine sanctions space, there are a number of executive orders, but the main one is Executive Order 14024. In that, the president signed that prior to the February invasion. It's about 3 years old. And in it, the president delegated both to the Secretary of the Treasury as well as to the Secretary of State the authority to impose sanctions and to name specific individuals, either for their conduct that renders them subject to sanctions, or for their status, for example, being an official of the government of Russia. When an individual is designated under an executive order under IEPA, the individual or entity is put on the specially designated national and blocked persons list, and the SDN list is found on Treasury's website. For compliance purposes, U.S. persons who do not want to run afoul of sanctions can go to the website, plug in the name of a person, of an entity or an individual, and to confirm whether they or their property is blocked by the authority. And I'll be happy to stop there and go to questions if anyone has any. Thanks.
Thanks. So I just wanted to wrap up by looking a little bit forward about some international law topics that you may see in the next months, years to come. And they're related to accountability. And here I'm talking primarily about individual responsibility for international crimes. And these are still being developed or in the process of building cases. So first, as just mentioned, Ukraine itself has war crimes prosecutions. The Office of Prosecutor General has received tens of thousands of reports of war crimes. And the US and several other countries are providing support and training to the Office of Prosecutor General, including through unique coordinated initiative between the US, the UK, and the EU called the Atrocity Crimes Advisory Group. Other countries are looking at potential war crimes prosecutions, including the United States, under our domestic law. And in Europe, several countries, including Ukraine, have formed what's called the Joint Investigative Team to facilitate the collection and exchange of information on international crimes. The International Criminal Court, the Office of the Prosecutor General, is investigating the crimes under its jurisdiction, and those are war crimes, crimes against humanity, and genocide. The ICC, the International Criminal Court, doesn't have jurisdiction for the crime of aggression. So there's been a lot of discussion about what mechanism might be able to pursue accountability for that crime. Ukraine has put forward a proposal. There are various academic proposals out there as well. But in the meantime, there are important interim steps that can be taken now to lay the foundation for accountability for the crime of aggression. So, for example, we were very happy to welcome the establishment of the new International Center for the Prosecution of the Crime of Aggression, which will be based in the EU Agency for Criminal Justice Cooperation, or Eurojust is the acronym. The center will support and enhance investigations into the crime of aggression by securing key evidence and facilitating case building at the earliest possible stage, laying the foundation for accountability by preserving and analyzing evidence for potential future trials. On the non-legal side, so those were all kind of legal mechanisms I discussed. There are also a variety of non-legal mechanisms that are aimed at either supporting these types of prosecutions or generally serving the role of promoting truth and information about what actually is happening in Ukraine. So through the UN, there are two. There's the Human Rights Monitoring Mechanism, and then also a commission of inquiry that was created by the UN Human Rights Council. So one thing you can look forward to is the mandate for this council, the COI is due to be renewed in March at the March Human Rights Council session. So you may see, hopefully the US is strongly supportive of renewing it. It's put out reports documenting war crimes and other atrocities in Ukraine, and we're strongly supportive of continuing that. At the OSCE, so again, not just the UN, but the regional organizations have been playing a role. There's something called the Moscow mechanism, and that is allows the OSCE to kind of create a panel of experts to review a situation. And so there have been 2 panels of experts that have reported on Russia's human rights abuses and violations of international humanitarian law or the law of war in Ukraine. And those reports are publicly available. And then finally, a lot of, as I mentioned, there's a lot of academic and NGO interest in what's going on. So for example, there's an independent collaborative endeavor called the Conflict Observatory that has received US funding, and it seeks to analyze and preserve information related to war crimes and other atrocities. And it looks at things like satellite imagery, information on social media, and documents it and preserves it in a way that would allow it to be used as evidence in a potential future prosecution. So that's all that I have. I'm happy to turn it back to you for questions.
Great. Thank you so much, Meredith, and thank all of you for those wonderful and very insightful remarks about the broader situation in Ukraine, and also specifically the work that the Legal Advisor's Office has done to support U.S. diplomacy on those issues. I'd like to remind everyone online that you can now submit and continue to submit questions for Q&A. We already have a number of questions that have been submitted during the earlier remarks, and I will share some of those questions, and I will direct some to the speakers if they respond to your remarks. And then other questions we'll just open for the entire panel and anyone that would like to comment. So actually, the first question actually relates directly, Meredith, to your most recent comments. As you can imagine, there's a lot of interest regarding the topic of accountability. And so the question is, what is the U.S. position on the various crime of aggression accountability mechanism proposals? And what impact, if any, do present circumstances have on the U.S. position towards the ICC? And I note others may want to comment on this as well.
All right, thanks, Darren. I'm going to take that that question, which is a very good question. There are various proposals that are being discussed, and what Ukraine has done together with its allies is it has established what they call a core group. It's about 20 states plus the European Union. We met recently in Prague. We're going to meet again in Strasbourg. And it is really to look at the legal issues that attach, if you will, to various models for holding Russian individuals accountable for the crime of aggression. As I think Meredith indicated, the ICC, the International Criminal Court, does not have jurisdiction over the crime of aggression here because Russia has not consented to its jurisdiction with respect to the crime of aggression. There are variations of the models that are being discussed, but I think probably the two that are sort of most dominant is one, which would be an idea either through a multilateral treaty, which can take a long time, or perhaps through an agreement with between the UN Secretary General and Ukraine to establish a tribunal. Ukraine has its own crime of aggression statute, hence all the domestic prosecutions. So that would be one model. The other model is something that's been referred to as a hybrid, which would take advantage of Ukraine's domestic law with respect to the crime of aggression, but in effect wrap it with international elements. So the idea being that you would have it would be grounded in Ukraine's domestic legal base, but you would be providing international prosecutors, hopefully maybe international judges. You would locate it perhaps at The Hague, international support in terms of evidence gathering and things of that nature. So one's more domestic based in Ukrainian law. The other one is arguably has more of an international nexus. There's a lot of tricky legal issues associated with both. And so that's the purpose of the core group, to see, what are the comparative advantages. So we haven't staked out a position one way or the other, but we are working through it with our Ukrainian colleagues and our close partners. As to the ICC, those of you who have, are not familiar with the International Criminal Court, I can say that this is an institution that the United States has had a varying relationship over the years. Some administrations are more supportive than others in terms of cooperation. We are not a party to what is known as the Rome Statute that formed the International Criminal Court. Historic U.S. position is that we have a robust system of accountability here in the United States, and that we're perfectly comfortable sort of prosecuting our own if they commit violations. That said, there had at one point, and it still exists on the books, legislation that sort of limits or precludes the amount of assistance that the United States can provide to the ICC, and certainly would never allow the ICC to prosecute U.S. service members. It's called the American Service Members Protection Act. There are exceptions to that, and Congress recently passed legislation that provides an explicit exception that would allow for the United States government to provide support to the ICC in investigating and prosecuting individuals who have committed war crimes in connection with the situation in Ukraine. So I think the bottom line at this point is we are supportive of the ICC's work in the Ukraine situation. It has a very skilled and very dedicated prosecutor. And we're also looking at these other mechanisms that we just discussed in terms of the core group. Thanks.
Great. Thank you very much, Rich. In addition to the questions that are being submitted online, we will also take questions from the room. So if anyone in the room has any questions, please identify yourself to our two folks floating with a mic, and they will come to you. I will continue with the questions submitted online. I think this question was actually submitted, Jessica, in response to some of your comments, particularly regarding Belarus. The question is, what standard or test does the USG use for determining when support for Ukraine would make Belarus, or for that matter, the United States, a belligerent in the ongoing armed conflict? So as we can see, there are no simple questions being submitted online, which Elle is used to, not receiving simple questions.
Really putting us on the hot seat here. So with respect to the analysis on Belarus that I talked about earlier, that was under draft Article 16 of the draft Articles on State Responsibility. And that's when a state can be held legally responsible for aiding or assisting another state. And one of the requirements of that analysis is that the acting state, if you will, has committed an internationally wrongful act. Now, separately from that, there are, of course, countless examples from the US and more than 50 other states of supporting Ukraine in its right to defend itself. That's a very different framework because, of course, Ukraine has not committed an internationally wrongful act. It is acting lawfully. But it is certainly our position that providing monetary or economic support is lawful. Many other states, as I said, are doing it. You may have seen in this question was probably alluding to Russia speaking out in the press about whether supporting Ukraine makes a state a, quote, party to the conflict. And it's hard to divine exactly what Russia's intending to get at with that idea. But I will say it's complicated. There are many different bodies of law at issue, like I talked about, but we would go back to the jus ad bellum. States cannot use force against other states unless they're acting in self-defense in response to an armed attack or in collective self-defense. The United States has been very clear, we are not using force against Russia. We are helping Ukraine to lawfully defend itself. So that's the distinction I would draw between those two ideas.
Great. Thank you so much, Jess. It looks like we have a question from the room.
Hello, thank you for your presentation. I'm Harman. My question was it's on the issue of reparation and compensation mechanisms for civil losses, especially the foreign investor losses in Ukraine, or especially the U.S. investor who had lost assets in the Ukraine's occupation region where their assets has been, expropriated. How can these damages claim be settled, recovered, and what are the available authorities for these international civil claims? Thank you.
Well, I think principally right now, the focus is on Ukraine and damage that's been done to Ukraine and to its citizenry. As I indicated, there was, well, let me step back. One of the UN General Assembly resolutions recommended the creation of what is known as a registry of damages. And the idea of that is to collect evidence of the damage that has been done to Ukraine and the Ukrainian people and interests, as well as those who've been living in Ukraine, and I guess conceivably that could include others. So the idea of the registry is that it will assemble information about the damage that has been caused and to whom and by whom, although in large measure it's basically Russia. That work is being done. I think Noah alluded to the fact that Ukraine has been working with the Dutch. The Council of Europe has also expressed interest in supporting that effort, and we have been advising Ukraine at a technical assistance level on establishing the registry. The next step, presumably, would be some sort of claims commission. And that is something that is further down the road, and that can take various forms. And the types of claims that I think could be recovered would be, people who've lost their apartments, their homes because of shelling, victims of sexual violence, and then, various other forms of damage. Now, obviously, they're going to be, so that will really be sort of, the idea behind that would be to provide compensation to individual victims. Now, obviously, Ukraine as a nation has suffered through the loss of its entire, not entire, but a large part of its infrastructure. Many of you may have noticed that the reports that Russia has been targeting the energy grid and doing so in the midst of winter, when in Ukraine it gets very cold. And so obviously that's going to have to be rebuilt. And that's probably going to take, the good graces and the good offices of the international community. There are also suggestions that, Russia ultimately should be paying for all of this. In fact, not suggestions, frankly, under the law, international law, Russia has a duty to make reparations to Ukraine. How that will be achieved and accomplished is going to be tricky because obviously Russia is not going to consent, at least at this moment, but perhaps they may down the road. Perhaps there'll be other means of achieving that. Thanks.
All right, thank you. It looks like we have another question and at the front of the room as well. And I'll ask when the speakers in the room speak, if you could just introduce yourselves and tell us where you're from.
Thank you. I'm Lourdes Bines from the Inter-American Bar Association. I just wanted to first express our solidarity and sympathy with the people of Ukraine. And second, thank you to all the panelists and organizers for this excellent event. I have two questions. I don't know if allow, but answer if you can. One is related to the Budapest Memorandum and how far can the US or the UK, for example, could go under that memorandum. How far can we go? Because clearly when it was signed, the assurance, weren't very specific about how far we would be, but clearly related to protection of the borders. That's one of the questions. And also, what is the situation of states who, even though they didn't sign the memorandum, like for example, China, they did provide assurance. So that's kind of one of the questions. And the other is if you could elaborate, probably that would be, I guess, Mr. David Sally, about the frozen assets, the whole process, if there are some reports that we can reach out to and how our allies are complying in the reporting requirements and the use for purposes of reparation, rebuilding, healing, the trauma of war. Thank you.
With respect to to be honest, the Budapest Memorandum is not something that has been part of the lively discourse today, but it's a non-binding instrument. So I don't know that it would provide a quote legally binding basis. And I apologize, I didn't hear your second question. Oh, frozen.
Well, a part of the question of the Budapest Memorandum was not only about the countries who sign it, and how far we can go in terms of, the support under the terms of those agreements. But then the other part was countries who didn't sign the memorandum, but provided assurance, as we understand. Correct me if that's not the case. And the other question was about frozen assets, the reporting, if we can get information about that in terms of the whole process, how it's being implemented, how successful are we being, and then the potential uses.
Right.
Thank you.
Yeah,
I can start. So it's important to recognize that legally sanctions are different from seizing assets. We use sanctions synonymously with freezing. So when we impose sanctions on a target and a target's property, that effectively freezes that target's property that is in the jurisdiction of the country or enforcing power. Other jurisdictions and countries like the UK, EU, Japan, Australia, Canada, other countries are in fact imposing sanctions on Russian persons. And we have a loose coordination with a number of those countries that's ongoing. When it comes to freezing, the only domestic authority that we have, when it comes to seizing assets, which is the next step, not just immobilizing them, but actually taking title to them and using them for other purposes. The Treasury has certain authorities in the context of enforcement of sanctions that requires the property to have been complicit in actual unlawful activity, as opposed to the broader power to freeze or to sanction. And there's been no broad international consensus on a seizure authority.
I would add to that, though, domestically, the United States has, as David alluded to, the ability to seize and forfeit assets that basically are rooted in criminal behavior, criminal activity, which can include sanctions evasion. And I think recently the Department of Justice announced that it had not only frozen but seized basically oligarch assets, those who have been sort of complicit and have been evading sanctions and sort of are the Russian oligarchs who've been engaged in sort of criminal activity, which, as I said, could include sanctions evasion for the purposes of the forfeiture laws. There are a number of sort of, I think, increasingly the other members of the international community. And I'd say this is an area where the United States and our European allies have not always seen eye to eye over the years on the reach of sanctions. But I think one of the great stories of, I mean, it's horrible to say a great story in the context of a horrible invasion, but the close coordination and the unity between the United States and other members of the international community in imposing sanctions and enforcing them, it has been remarkable. And I think going back to what I started off with, which was, many thought Kyiv would fall in the early days. Well, not only didn't it, but there was so much international activity and activity on the part of the United States that sort of prevented Ukraine from falling. And then also immediately counterpunching with sanctions to inflict a toll on Russia. And I would just note one thing in regard to the former point there, which is, and we really haven't touched on it. There are so many legal issues in this area. It's every week we talk to our international counterparts and we say, okay, what's the next legal issue coming down the pike? We've met with our colleagues in the G7 group, probably 40 times in the last year. But one of the things that I think was really critical for the United States was the willingness to declassify and make public certain intelligence. Not only so that we could say, yes, Russia, we know you're coming, we see you coming, and tell the rest of the international community, but then also to sort of document the horrible things that Russia has done. It goes to that thing, what good is the intelligence if you can't use it? Well, happily, I can say that in this instance, the intelligence has been good and we have used it. And I suspect that's much to Russia's benefactors' chagrin.
I know some of our students have to depart shortly for class, so we're going to take one student question. We'll take a couple, and then I know we have a question from one of our co-sponsors. Go ahead, Gerald.
Hi, my name is Gerald Ramirez. I'm a 2L here at Howard. Thanks for being here. My question is, how do you respond to Russia's argument that their actions in Ukraine are a response to, quote unquote, NATO's expansion eastward? The idea being that Russia is asserting a right to control a sphere of influence, just as the United States does, on this continent.
Well, Russia doesn't have a right to commit aggression. They're plainly in political terms, there are, groups of allies, et cetera. But NATO posed no threat to Russia. I think that was very much sort of a convenient trope on the part of Russia. And obviously what we have seen is because of their aggression, yes, NATO has expanded. We've, Finland and Sweden are joining. And that was done, those were two states that historically sort of valued sitting on the fence. And when their population saw just how horrible the things that Russia was doing, the tide in those countries turned very quickly. And I was at the NATO conference last May, and it was amazing how quickly not only the decision and then the support and then the ratification of their instrument of accession by our U.S. Senate happened in a matter of months. From an international law standpoint, that was lightning speed. And so, Russia says a lot of things, but perhaps they should think about the consequences before they act on those statements.
Okay, we have time for a couple more questions. So, Michael.
Thanks, Darren. Michael Cooper, I'm the Executive Director of the American Society of International Law. Much of the really thoughtful analysis that we've heard here today unfolded before us is based on the premise that the referenda were sham referenda. I think they were sham referenda, and you think they were sham referenda. But I'm wondering, is there a more rigorous test under international law for that? I was reminded of the test that one of our Supreme Court justices put forward with respect to pornography, the I know it when I see it test. So is it simply an I know it when I see it test? It's a sham referenda, or is there some other methodology in play? I know that the General Assembly had addressed this and declared these illegal, but is that a political determination or a legal determination? So I was wondering if you could just try to unpack that for us a little bit. Thanks very much.
Sure, I'm happy to address that. I mean, I think this wasn't, I think you have a good question if it were a close call, but this wasn't a close call because Russia had engaged in aggression to control territory and then tried to paper it over with these. And just to give you a sense of why it wasn't a close call, you know, the timeline between the announcement of the so-called referenda and them happening, it was like a matter of weeks. And they were organized by the officials that Russia had installed in these areas that, you know, were their officials. So it wasn't really a close call, but, you know, I think what was persuasive to the international community was, for example, the Friendly Relations Declaration, which elaborated on the principles the UN Charter expressly states that you cannot acquire territory through the use of force. So once you have that initial use of force that allows Russia, unlawful use of force that allowed Russia to control the area and then force these so-called referenda on people, it's like, you know, in American legal terminology, the fruit of the poisonous tree. You know, how could those be free and fair elections in any form? How could it really represent the will of the people in any way? So that's why I don't think it was a close call. So I don't think it was a hard legal or policy analysis in that situation. Yeah.
Hello, thank you so much. Colleen Graffi, I'm a law professor at Pepperdine Caruso Law School in Malibu, California. And I'm wondering if you can talk about the implications in the war with regard to the Black Sea and Russia's actions there on the Black Sea. And in particular, I note that several senators are really keen on this. Senator Jeanne Shaheen, for example, questioning the Montreux Convention from 1936 that was supposed to bring security and stability in the Black Sea, and instead it's turned it into a Russian lake. And I note that the next window of opportunity for amendments is August 2026, turning the spotlight on the work that your office does. What would that look like for your office if you were asked to renegotiate that? What would the process be? Thank you very much.
Well, first I want to say, please give our regards to our former counselor of international law, Professor Pepperdine Trey Childress, which is my way of filling in a little time for a very difficult question. Actually, the Montreux Convention, for those, sometimes I think, you know, we need more cities because there's a couple Montreux Conventions, but the one that the question is directed to is a convention that regulated access to the Black Sea. And it was sort of designed to avoid, and by that, I mean, access from the Mediterranean through the straits that are controlled by Turkey into the Black Sea. And the idea being that only that vessels whose home port was in the Black Sea could return to those home ports, but otherwise other vessels going into the Black Sea would be controlled. And so it is a bit of a, it's a very old treaty. It was probably one of those treaties that was not designed for these times. I will say early on, Turkey did a very good job, and I confess I have not heard of any complaints since, but they were implementing the treaty as they should, which was great. Another sign that a lot of states have really stepped up. This has not just been the United States that has been supporting Ukraine. It's been international. But to your longer question about 2026, I mean, my God, that seems like a lifetime from now. And so, but in true L fashion, I will commit, we will look at this issue, which you have helpfully raised, and and see if something productive can be done.
Thank you very much, Richard. Well, we have so many more questions, but so little time. So I will take this moment to thank all of our panelists for their very thoughtful comments and answers. And please join me in thanking them, giving them a round of applause. I'd also like a moment to take a moment to acknowledge some specific individuals who made this event happen. We would like to, of course, acknowledge with a special recognition to Ron Batower, former Deputy Legal Advisor in L, who was really the brainchild for the Live at L, which this is the 13th annual Live at L event. We'd like to thank Robbie Nightingale for his work. We also would like to thank the primary ABA International Law Section, who was the main sponsor of this event, and Renee Doplick and Lavinia Cousin for their wonderful work in bringing this about. From the American Society of International Law, another sponsor of the event, we'd like to acknowledge Michael Cooper and thank him and Wes Rist for their wonderful work and support for the program. We would like to acknowledge the George Washington University Law School, a co-sponsor of this event, and in particular, Associate Dean Rosa Solario. And finally, within the Howard Law community, we would like to thank Dean Holly for her wonderful support for the event, LaShawn Reeder and Paul Mollison for their support in bringing the event together, and of course, our International Law Society members, Mike Lynn, Sage Stewart, Favor Okavibi, Sarah Shafiq, Crystal Bush, and Gerald Ramirez, who really helped to make this a success today. And finally, we'd like to thank all of you online and here in person for joining us. This has been a wonderful discussion, and we're so glad to have had you here.